right, guys, welcome back to another edition of Lawyered Up. I am your host, Jared Moore, and once again, for the record, I am not a lawyer. Today's program, we're just going to have an update on some motions that were filed at the Supreme Court in the Grayson Kennedy case. If you guys remember from last time, we talked about the press conference that DeMario Solomon Simmons had, where he announced that they had filed these motions and the Supreme Court hadn't posted them to their website yet. Well, those have been posted, and also some other stuff like a new order to have a second status report. So let's take a look at the stuff that's been posted. So you guys know the drill here. This is the Supreme Court of the Mvskoke Creek Nation's website. I'm going to go to Final Opinions. I'm going to scroll down here to Grayson and Kennedy. And then if we look at the list here, now we have the respondent's third motion for contempt and respondent's motion for temporary restraining order and preliminary injunction. I think last time the link that we provided you guys was this temporary restraining order. But if you want to read the motion for contempt and court enforcement of order and judgment, you can read that on the Supreme Court's website. You'll also see here that there was a motion to file an amica curiae brief by the NAACP and the Legal Defense and Educational Fund and Lawyers Committee for Civil Rights under the law. This down here, you can see that this was denied. And if you want to read these, you can, but the Supreme Court basically denied their motion to file an amicus because they were outside of the 15-day window that they could file that request or file that amicus. So they're outside the window, they can't file it. What I wanted to talk about mostly today was this order directing appellate to submit a second status report and holding respondents' motions in abeyance. So let's go to that order. I'm going to read through most of this just because, so we could get caught up. This is what the Supreme Court's order, and I'm going to start down here. As of the filing of this order, over 200 days have passed since the court issued its August 20th, 2025 order denying appellate's petition for rehearing, finalizing this court's opinion in the above-styled action. However, as of this filing, the appellant has not complied with this court's order to issue citizenship to the respondents or any other future applicant who is able to establish a lineal descent on the Creek by Blood Dawes Roll or the Creek Freedman Dawes Roll. This court understands that while its July 23rd, 2025 order and opinion did conclude that any reference to by blood citizenship, specifically in the 1979 Mvskoke Creek Nation Constitution, but also in the Mvskoke Creek Nation Code or in any association Mvskoke rules, regulations, policies, or procedures is unlawful and void ab initio, it is still necessary for the nation to fill these legislative voids with new law that will comply with the Treaty of 1866 as explained in this court's order and opinion. This will require the cooperation of the legislative and executive branches of government and may take a reasonable amount of time to accomplish. The emphasis there is the court's on reasonable. The court acknowledges the Appellate Citizenship Board's efforts in circulating draft legislation between these two branches of government and in attempting to obtain status updates from the Principal Chief and National Council. The court also acknowledges the respondent's frustration in waiting what may feel like an unreasonable amount of time for the relief this court has already ordered. For the time being, the court continues to trust that its co-equal branches of government are applying all due effort and speed to this important task. This effort will require continued and speedy cooperation by the executive branch in these proceedings, as well as cooperation by the legislative branch to fulfill its constitutional duty, promptly reviewing and enacting proposed legislation submitted for consideration in this matter. In order for respondents' pending applications to move forward, the legislative branch must enact laws and/or procedures to comply with this court's July 23, 2025 order and opinion. Now, this is an interesting part to put in here, I think. The judicial branch of the Mvskoke Creek Nation does not contain an enforcement division. This is absolutely true. The court relies significantly on the legislative and executive branches of government to see that the court's constitutional interpretations and judicial rulings, including findings of contempt of court, are carried out through policies and procedure, legislative changes, or enforcement actions via executive departments such as the Light Horse Police. So I'm going to scroll down here because this is kind of a recap, and if you guys have been following the coverage, you will remember all of this stuff that happened about the executive order and everything. If not, you can go back and check that out. So I'm going to go ahead and skip ahead here to the order. It is hereby ordered that the appellate and the principal chief shall submit a second status report to the clerk of the Mvskoke Creek Nation Supreme Court on or before close of business on Wednesday, April 22nd, 2026, providing written responses and or documentation in response to the following questions. 1. Provide the court with an update covering the time since the appellant's December 5th, 2025 status report, addressing each of the questions previously submitted in the first status report, November 13th, 2025, including specifically any new communications with the principal chief and or national counsel, and any updates concerning specific legislation, policies, or procedures being considered. 2. Has the Office of the Attorney General, as counsel of record for the appellate and for the executive branch in this action, drafted proposed legislation creating law and or procedures to implement the court's July 23, 2025 order and opinion? If so, provide true and correct copies of any draft legislation. If so, has the Office of Attorney General provided this draft legislation to the National Council for consideration or sought a sponsor? 3. Has the appellate or the executive branch sought and or obtained a National Council representative to sponsor legislation creating procedures to implement the court's July 23, 2025 order and opinion? If so, which representatives have agreed to sponsor this legislation? If so, provide a true and correct copy of the draft legislation to be considered by the National Council. If no sponsor has been sought, provide a summary explanation described the reasons a sponsor has not been obtained. 4. Provide an updated timeline for compliance with the court's July 23, 2025 order and opinion. It is further ordered that the respondent's December 18, 2025 objection and motion for leave to respond, the respondent's March 9, 2026 third motion for contempt for court enforcement of order and judgment and for order to show cause, and the respondent's March 9, 2026 motion for temporary restraining order and preliminary injunction shall be held in abeyance, filed and entered March 23, 2026, which is today. So the court got this up the same day, which is great. Thank you so much for that. Now, what I wanted to touch on before I switch off of the screen here is this phrase, held in abeyance. You may be asking yourself, what does that mean? Because I didn't know what it means. But let's look at the the definition of it. Let me make that a little bit bigger so you guys can see it. Abeyance is a temporary suspension of activity while awaiting the resolution of some other proceeding without which the activity in abeyance cannot continue. So, I'm assuming that the Supreme Court is saying, until we get the status reports, all figured out, and we have all the status reports that we want, we're going to not do anything about these motions, right? So that's what the abeyance means. The other thing I wanted to talk about is another definition of something, because I've had a lot of citizens that have just, are just talking to me as a citizen myself, and they're saying, what happens if the executive branch or the National Council, both of them, just refuse to do what the court has ordered, right? What'll happen? And I want to be clear that this isn't currently happening right now. the executive branch and the legislative branch and everybody have agreed that they're trying to do what the court has ordered them to do, right? Just like what the Supreme Court's order says, and the Supreme Court also believes that. But it is good to know what a possible outcome could be. So, and that is constitutional crisis. So constitutional crisis, you may have heard it, in the news because of what was happening years ago with the federal government. But I'm going to scroll down here a little bit and read you here. In the course of government, here's where I am. In the course of government, the crisis results when one or more of the parties to a political dispute willfully chooses to violate a law of the Constitution or to flout an unwritten constitutional convention, or, this is for us, to dispute the judicial interpretation of a constitutional law or of the flouted political custom. So basically what that is saying is, like if you have a government that has different branches, and the judicial branch, the Supreme Court, interprets the Constitution and says the Constitution says this, or in our case, this part of the Constitution is void ab initio, and the other two branches don't agree with them and don't do what they order them to do, then you have a constitutional crisis. Let me pop this up. What can happen if a constitutional crisis does happen? Again, we're not there yet, but so this is the bad part. Constitutional crisis can lead to administrative paralysis and eventual collapse of the government, the loss of political legitimacy, democratic backsliding, or to civil war. So I don't think civil war is going to happen here. Democratic backsliding is kind of a thing that we do anyway. The loss of political legitimacy would, if this happened, would absolutely come about, and the eventual collapse of the government would be a danger. I just want to clarify with you guys, that's what a constitutional crisis is, and one of the ways a constitutional crisis can arise is if the two other branches don't recognize the authority of the third to interpret the Constitution. We're not there yet. I know I've mentioned it 2 or 3 times. I don't want you guys to think I'm saying we're in a constitutional crisis, because the Supreme Court's order here that we've just read through, the Supreme Court itself says, we believe that the executive branch and the legislative branch and the citizenship board and everybody here is trying to cooperate with the order and trying to fill the legal voids created by saying by blood is void ab initio, right? So the Supreme Court thinks everybody's cooperating. The executive branch has said they're cooperating. The legislative branch, everybody said they're cooperating with us. But if we get down the road and they decide, we're not going to do it, or if the Supreme Court holds them in contempt, we'll have to just wait and see what happens at that point. But those are the dangers, and they're pretty big. So we're going to keep an eye on this case, guys, and the deadline, again, let me go back to that. The deadline for the next status report will be, you can see, is Wednesday, April 22nd, 2026. So they've got, about exactly a month almost. It's the 23rd today, so it's about a month away. And once we get the status report, or whenever it gets posted, we'll have another show about that. Don't forget, we will also be having an update on Representative White Cloud's felony charges on April 6th, because she's got a court date in the district court. And I went ahead and went through all of the cases that we've been following, and there's not any other significant updates to anything. And thanks for tuning in, guys. I appreciate you dropping by. I don't see any questions or anything in the chat, so I'm going to go ahead and sign out for today. And Mado Hadam Chihichat Lease.